That's a problem. It's your criminal history. 96. That's one of the most I've done this for a long time. Thousands of cases. Well, you are one of the most prolific criminals that have set foot in this room. And I guess you have used similar kinds of sad stories to others to try to minimize your responsibility. But this is nothing to be proud of, and it's not anything that this court can really sympathize with you. People come in here, everyone comes in here. Maybe one or two out of the thousands have been more prolific in their criminal actions, quantity of crimes more than you. But all of those thousands of people that come before me could say, Miss Tiffany Marshall, she had 97 convictions, and you let her kind of sashay out of here. And I'd like the Tiffany Marshall rule, please, because aren't you supposed to be fair, Judge? Yeah, I am. I should be fair. And everybody is to be judged based upon their criminal history and character. And this is very poor character. And your criminal history is most prolific. This court is not going to change the rule of law, which states people are responsible for their bad acts, their criminal acts. They must be held responsible. Anything else?
Well, I don't know that all of the theft by check citations were convictions. I know that she said she handled most of her things by paying her checks off, but the other thing is, I would ask the court that if the court is not willing to allow her to be on probation, and even though she got a year, the last time she had a state jail felony, we would ask that you consider something on the low end, 6 months, or even a 1244, in light of her other problems that we would have to, as the taxpayers, have to deal with because she's so ill. So I would ask the court, if you're going to send her to jail, that you consider something on the low end.
Anything else? If not, on that argument, truly, then people who are seriously ill have carte blanche to do pretty much anything they want, and everyone has some form of situation health-wise that they're dealing with. Even the most healthy people are not perfect. I so find you guilty. I'm following this agreement. You are hereby sentenced to confinement in the state jail for a term of 15 months. You will be given credit for all time that you have served in accordance with this. Your lifestyle, see, Ms. Marshall, you have a lifestyle that you feel shocked that committing crimes should hold you accountable. You have 96 infractions of law, 96, and you are committing these crimes with special tools for getting away with attempting to commit your theft. You have specially made tools that are used in the commission of your crime. You can't, a judge cannot be lenient with you. You cost everybody. You are a one-person crime wave. It's thefts that cost everybody more money at merchandise stores because their theft, the loss is so high. We have to pay for your criminal acts. But after 96 times you have had to go deal with crimes in various courts, from felony courts to misdemeanor to Class C misdemeanor courts, you would have gotten the message, and you never have. You just are a career criminal.
Courtroom silence usually means uncertainty, but in this case, it means something very different: finality built on repetition. When a judge reaches the point of referencing nearly 100 prior convictions, the conversation is no longer about what happened today. It becomes about what has already been proven over time. Every new explanation, every attempt to reframe circumstances, loses weight because the pattern has already spoken louder than the arguments. What stands out most is not the sentence itself, but the erosion of credibility that leads to it. The court is no longer evaluating isolated incidents. It is evaluating a history that has repeatedly returned to the same outcome. At that stage, mitigation arguments, personal circumstances, or emotional appeals don't disappear because they are irrelevant, but because they have already failed to change the trajectory in the past. And in legal reasoning, past failure becomes future expectation. This is where accountability stops being reactive and becomes structural. The system shifts from asking what should happen now to what has already been tried, and why did it not work? That shift is what defines cases like this. It is not the intensity of one moment in court that drives the outcome, but the accumulation of many moments before it. And once that threshold is crossed, the judgment is no longer unpredictable. It is simply the conclusion of a pattern that has already been written over time, and the courtroom only reads it out loud at the end.